Davidson, and together with Aeyal and Eliav Lieblich, I convene Tel Aviv University's International Law Workshop. This roundtable on the apartheid debate in Israel, Palestine, and international law is a special session of the workshop that we organized in collaboration with the Minerva Center for Human Rights here at Tel Aviv University. Among the audience, we have students registered for the workshop, other members of the law faculty, and members of the public at large. Thank you very much for joining us. And my co-conveners and I are particularly thankful to Yuli Litov, the Minerva Center's new executive director, who has been extremely helpful and resourceful. We will very shortly hear from 6 distinguished speakers who will present a range of perspectives on the question of whether Israel's actions in any part of the areas controlled by it are properly characterized as constituting apartheid. The speakers' bios will be available in a document that will be shared very soon in the chat. Before turning to our speakers, a few words of introduction are in order. Claims that Israel has instituted an apartheid regime in the occupied Palestinian territories or within Israel's recognized international borders are not new and have been voiced by Palestinian groups such as Al-Haq for years. However, these claims have recently become more frequent and visible. In 2018, the State of Palestine submitted to the committee monitoring the Convention on the Elimination of All Forms of Racial Discrimination, Sfard, a complaint against Israel, claiming that Israel is in breach of Article 3 of the Convention, which prohibits apartheid. The claim has not yet been addressed on the merits, but the committee declared it admissible. Just last week, the UN Special Rapporteur on the situation of human rights in the occupied Palestinian territories, Michael Link, published a report concluding that Israel's conduct in occupied Palestinian territory is in breach of the prohibition against apartheid. In the past year, 4 human rights organizations, 2 Israeli and 2 international, have published papers claiming that Israel infringes the international prohibition of apartheid, though these reports differ on the geographic scope of such apartheid and the date at which it began. These organizations are Yesh, B'Tselem, Human Rights Watch, and Amnesty International. Representatives of 2 of these organizations are on the panel today, and I believe there are representatives of the others in the audience. So very briefly, what are we talking about when we talk about apartheid? Following the lead of Palestine's complaint, the Special Rapporteur and the NGO reports, and because we are a workshop focused on international law, today we are talking primarily about apartheid as a prohibition in international law. Apartheid is, of course, also a historical phenomenon. Specifically, it's the policy of racial segregation practiced by South Africa most of the second half of the 20th century. And beyond South Africa, for political scientists, it's a type of political regime, and for legal theorists, it's a type of legal regime. But the primary framework for our discussion today is apartheid in international law, though of course, it's very difficult to completely detach the historical analogies and the political and legal context from the international legal norms. So what is apartheid in international law? The prohibition of apartheid is a norm imposing obligations on states in international human rights law and international humanitarian law. And it's a norm in international criminal law that can lead to individual criminal liability. The State of Israel is bound by this norm, not only because it is enshrined in Article 3 of Sfard, to which Israel is a party, but also because the norm is considered customary and peremptory. Sfard does not define apartheid, and therefore scholars turn to the prohibition of apartheid in international criminal law in order to inform the content of the state obligation. International criminal law categorizes apartheid as a crime against humanity and provides 2 definitions. The Apartheid Convention defines apartheid as the commission of inhuman acts, and these include the denial of certain basic rights, legislative, and other measures calculated to prevent a racial group from participating in the political, social, economic, and cultural life of the country, the deliberate creation of conditions preventing the full development of such a group, and certain measures designed to divide the population along racial lines, when these acts are committed for the purpose of establishing and maintaining domination by one racial group over another and systematically oppressing them. The Rome Statute of the ICC has a similar definition. This is the framework for the present discussion, or at least it's the starting point, a common starting point for those on the panel or in the audience who may wish to challenge this framework. We will now turn to our speakers, who will have no more than 10 minutes each and will be strict. After they are done, we will have 45 minutes of Q&A. To participate in the Q&A, we ask that you raise your hand electronically, but only once all the presentations are done, and we will call on you and take questions. So our first speaker is Michael Sfard. You will soon see his full bio in the chat. I'll just say that Michael is a human rights lawyer specializing in international human rights law and the laws of war, in particular the law of belligerent occupation. And he's the legal advisor to a number of human rights organizations, including Yesh. Thank you, Michael. The floor is yours.
Thank you, Natalie. Thank you all for coming and joining this very important discussion. And I thank the Faculty of Law in Tel Aviv University for organizing this. I think it's a very important discussion to hold. I had many challenges in my career, but to discuss apartheid in 10 minutes, this is a new one. I'll do my best. I'll start with saying that in June of 2020, Yesh has published the legal report that I have authored on the question of the commission of the crime of apartheid in the occupied West Bank. And while it was, at least in Israeli and international terms, quite radical back then, less than 2 years have passed. And now it seems like our report is, to put it mildly, in the middle of the road, or even considered conservative in some way, because it does focus on the West Bank. So I'll start by saying that Yesh is an Israeli human rights organization that works in the West Bank, representing Palestinian victims of Israeli abuse in all sorts of ways. And for the last 17, by now it's 18 years, we've been working very intensively in this area, getting to know very closely the Israeli practices, policies, and of course the normative framework of the military occupation in the West Bank. And while at the beginning we thought that the legal paradigm of military occupation is the paradigm that we should work with, as time went by and as we got to know better the reality in the West Bank, we realized that the paradigm of occupation is not enough, that it cannot carry on its thin shoulders the full weight of what we're witnessing and experiencing in the West Bank. And of course, the main contender for a new or an additional framework was the crime of apartheid. And indeed, for the last several years, we've been looking into this, studying the issue. And our very sad and embarrassing conclusion as Israelis was that the crime of apartheid, the international crime against humanity of apartheid is being committed by Israel, by Israelis in the West Bank. That does not absolve Israel, or it is not a assertion of acquittal for any other area between the Jordan River and the sea. We have looked into what we know best and according to our mandate. And I think it's very easy. It's one of the easiest tasks that I have as a lawyer to prove that the crime of apartheid is committed in these areas. There is no question that Israel is maintaining a regime of domination and oppression of millions of Palestinians, and every belligerent military occupation is like that. The difference in the Israeli occupation is that it is, or the important feature of the Israeli occupation that brings it to the realm of apartheid is the fact that we have colonized the occupied territory for years and created there two communities, one of Israelis who have all the civil and political rights that any citizen has in a modern country, and one of Palestinians, millions of Palestinians who have whose rights have been suspended for the duration of the occupation. They have no right to vote or to be elected, to run to government, and in fact, they have no say in the corridors of power where their fate and future is decided. And naturally, that brings about all the evils that the prohibition on a transfer of civilian population from an occupying power to the occupied territory is meant to prevent. That all the resources of the land are being diverted to the occupying power's citizens, in this case, the Israeli settlers. And in fact, it is done in a very blatant way. I'll give you one figure. 99.76% of lands that were allocated, of public lands that were allocated by the civil administration since 1967 have been allocated to Israelis and to Israeli interests. Only less than 0.25% of public lands were allocated to Palestinian use, and more than half of that for use of communities that we have forcibly removed from their place of inhabitation in order to expand settlements. So that's only one example. There are, in every dimension, all the resources of the land are being taken from the indigenous Palestinians and allocated to the Israeli immigrants. So we have a context, the context element of the crime, of a regime that systematically oppresses and dominates the Palestinians. There are two groups, one is dominating and oppressing the other. So that's the context that we have. And we have ample of inhumane acts that some of them come to the parameters of the crime of persecution, of denying rights on basis of group affiliation, expropriation of lands, forcible transfers, the dual legal system in which Israelis enjoy modern laws that have been enacted by the representatives in the Israeli parliament, while the Palestinians are subjected to a cruel and draconian military legislation. And I can go on and on and on, but I only have 10 minutes and I still need to get to two more points. And one is that the third element of the crime, the intent, the special intent of maintaining that regime, that was the alibi throughout the years that Israel could or wanted to use in order to refute the severe allegation. Now, I'll say two things about it. First of all, there were times when Israel has made the right statements. It used the right words. And it did use the argument that this is a temporary situation, that we are in a peace process, that the end goal is not to dominate Palestinians. These words were in complete contradiction always to Israel's deeds. And if, again, as a litigating lawyer, if I had to prove a case, to bring a case, to prove that Israel's intention has always been to perpetuate, to eternalize, from the word eternity, the domination over the Palestinian lands, that would be one of my easiest cases to prove, because Israel's deeds speak for themselves volumes. But there was a clash between deeds and words. This clash is over. Since 2017, when Trump entered the White House, Israel came out of the closet. And the Israeli government has engaged in a vocal, clear, transparent policy of gradual annexation. And that policy is with us. And not only a de facto annexation, which is done on the ground, but also a de jure one. So today, the gap between words and deeds is completely lost or closed. And so the question of intent to perpetuate, to maintain that regime is there. And we have a prime minister that openly said to the New York Times, we're not about to allow them to be citizens of Israel and not to form their own state. So, well, where are we heading with this? More settlements, more roads, more confiscation of land, and more driving the Palestinians into their enclaves, small, ever small shrinking enclaves. So for me, it's a no-brainer. Israelis, because it's a crime, and the crime is done by people, not by states. Israelis are committing the crime of apartheid, definitely in the West Bank. Now I want to say 2 words about the geographical scope, because that is the one thing that there are nuances between the different reports. And I don't want to say anything conclusive, but I want to mention 2 issues that should be taken into account on that question. In order to answer the question of the geographic scope of first of all, crimes are done in a certain place and a certain time. Every indictment begins with, or it should include, a place and a time where the crime has been committed. So the question of where the crime of apartheid is committed is the question that we should ask ourselves. Now, one issue is, what is the geographical scope that we should analyze this question? Can we analyze distinctly the question of the commission of the crime of apartheid in the occupied Palestinian territories and in Israel per se, or should we definitely look at the whole region between the Jordan River and the sea as one unit? Now, I, for one, think that the fact that there is one political power that dominates the full territory does not mean that we cannot analyze the question of the commission of the crime in different areas where we have different normative frameworks, different governing institutions, different policies. Israel and the OPT are constantly in a process of unification. That's true. At what time we would not be able to say anymore that there are 2 regimes or 3 or 4 regimes that Israel applies, that the Israeli government applies in the territory? That's an open question. Can we still say that the OPT is a distinct regime from Israel? I think we can. And that means that we can analyze the question separately into the 2 areas. And we can also decide to analyze it in the full territory as one unit. I just think that these 2 options are open for us. Now, the second question is about Israel proper. Proper meaning in the green line boundaries. Can we say that this is an apartheid? And in this issue, I want to say the following. There is no question for me, and this is not a Yesh Din statement. I'm leaving my mandate to talk on behalf of Yesh Din, because Yesh Din does not operate in Israel and we have not spoken. I'm talking only in my own accord. Israel is an ethnocracy. The concept that was coined by my good friend and exquisite scholar, Professor Oren Yiftachiel. It is an ethnocracy in the sense that the question of belonging to an ethnic group or national group determines your rights, determines your future, your well-being much more than the membership in the citizenship in Israel, and we cannot deny it. But what makes an ethnocracy an apartheid? That's the question. Because once we have a system where all people enjoy the basic civil political rights to vote, to be elected, to run to government, to affect the future, then the bar is very high to prove that while this is happening, while all these rights are ensured, it is still an apartheid regime that is based in a central way on a feature of maintaining superiority of one group and coercing inferiority on the other group. And that is a big question. When? Because it's a question of intensity. It's not just a question of whether there is systematic discrimination. And yes, Israel systematically and systemically discriminates against its non-Jew citizens, against its Palestinian citizens. in all forms of civic life. And does that mean immediately that it is apartheid? My argument is we need more than that. There are many, many nations that discriminate against minorities. Not all of them are apartheid regimes. Now, whether Israel is or not, that's an open question, and I think it's a very important question to debate. But the fact that there is systematic discrimination is not enough. The crime against humanity of apartheid demands a very high bar of supremacy and inferiority of one group and another group. I don't know if I have more time, Natalie.
No, that's it. Sorry, you will.
I just want to say that I have much more to say, but fine. Thank you. Thank you for the opportunity.
Thank you very, very much. Thank you very much, Michael. And now we move on to Solomon Sacco, who for the past 9 years has been Deputy Director of Law and Policy and the head of the International Justice Team at Amnesty International. He was a legal advisor on Amnesty International's report on apartheid in Israel and Palestine. Thank you very much, Solomon.
Thank you, Natalie, and thank you for the introduction to the legal system. And thank you, Michael, for putting me on the spot in many ways, because as you know, Amnesty International is an outlier, as the New York Times put it, in that we have analyzed the situation and we have concluded that there is one system between the river and the sea, to coin a phrase, and that system is one of apartheid. And I'll preface my remarks by saying quite clearly that we do not conclude that the situation within the Green Line on its own amounts to the system of apartheid, whether as a violation of public international law, of international human rights law, or as a crime against humanity. We are quite clear that what we do is we analyze the system as a whole. So those are some of the prefaces, but having said that, I'd like to step back and sort of explain our thinking a little bit more around the crime against humanity of apartheid, the human rights violation, and the human rights and the international wrong of apartheid. So our understanding is that apartheid is a crime against humanity, but in many ways it is much more. It is an egregious violation of the UN Charter, and that's clearly stated by the International Court of Justice in its 1971 opinion on the situation in Namibia, but then Southwest Africa. It has been condemned since 1950 by the UN, both as a crime against humanity, but also an international wrong in the sense of a violation of public international law, a violation of the rights of peoples to self-determination. The Security Council and the General Assembly also referred on numerous occasions to apartheid as a crime against humanity. So already in the 50s, 60s, and 70s, you have consensus building that apartheid is a crime against humanity and should be punished as such. And then, of course, you have the UN Convention on Apartheid, and then you have the Rome Statute of apartheid. So if going back to our huge report, which I do ask people to read in its entirety. I know it's quite long, but it's quite interesting. We try to look at apartheid as those three things, but primarily on one level as a violation of human rights, looking at the 1971 decision in the Namibia and public international law. We look at apartheid as a human rights violation, and then expanding that into the individual criminal responsibility question, which I think is what interests people most currently about apartheid. And we look at it in both terms, because from our perspective, what's most important is to dismantle the system of apartheid as practiced across the territory that is controlled by Israel. And to do that, obviously, there must be accountability for those individuals who have perpetrated the crime, but it's also important to identify state responsibility and identify the elements of that regime, that system, that needs to be dismantled. So in our understanding of apartheid as a human rights violation, it's a system of laws, policies, and practices that ensure the prolonged and cruel discriminatory treatment by one racial group of members of another with the intention of controlling the second racial group. So it's a system of oppression and domination, in short. And then the crime of against humanity under customary international law and the Rome Statute is any inhuman or inhumane act, a serious human rights violation, committed within the context of a system of laws, policies, and practices that ensure the prolonged and cruel discriminatory treatment by one racial group of another with the intention to control, and then C, with the special intent of maintaining that system. Now, my understanding of current intent, and I think this is, for us, this is something that will come back to apply throughout our analysis, is what is the intent? So the defense, obviously, and that's been referred to originally, is that the state of Israel has an obligation and a right to ensure security. And obviously Amnesty International recognizes that, and indeed expects that all states will do their best to ensure security. However, not just from 2017, but throughout history, you have had general consensus that Israel will use its laws and policies to ensure the privileging of Jewish Israelis over Palestinians. And in our report, we show how this history has developed. And ultimately, that the intention is to ensure maximum Jews on maximum land with maximum security and with minimum Palestinians. Those are not my words. I'm sure everyone will know where they come from. However, I think that will ultimately be the question. I think intensity is not the question. Intention will always be the question that we need to show, that this discrimination, the structural discrimination that you see across the whole of the territory is not incidental, it is not accidental. It is put in place with the intent to ensure Jewish Israeli control over resources and a minimizing of Palestinian power. So in our analysis of the situation, we have identified four essential pillars of this system, which are territorial fragmentation, segregation and control, dispossession of land and property, and denial of economic and social rights. I think territorial fragmentation, and the more I listen to Palestinian lawyers and experts, the more you see the importance of territorial fragmentation in the system of control. So Palestinians are fragmented between the West Bank, the East Jerusalem, Israel within the Green Line, and Gaza. And their rights and ability to engage in civil affairs, to enforce their rights to property, to move, to marry, to fall in love, all of that is determined by that fragmentation in a way that Jewish Israelis are not limited by that. I have been to Palestine and to Israel, and it strikes you how there is only one system if you are Jewish Israeli. You can move freely, you can travel across, you can go into the West Bank, you have family, you have friends in settlements, you may live in a settlement, you may travel throughout the area. There is only one system. So it's very strange to me to then argue that one group, the group that benefits from the system, is more or less unencumbered by the different systems, whereas the other groups are in varying ways and varying degrees. Then to try and analyze the different situations in different ways misses the whole picture, misses the intent that is visible throughout the law and practices. So again, I think it's interesting when we started this work 5-6 years ago, I think arguing that apartheid was being perpetrated in the West Bank was itself an outlier as a legal position. Now it's almost taken as given. I think there's general consensus on that. And the question then becomes, can you separate out the beneficiaries, to say that the areas where the beneficiaries predominate, in ways that would be like going to South Africa in the ends, but there is no part the southern suburbs, and I think that misses the full entirety of the system, and I really look forward to the conversations, but I just wanted to leave it there, really.
Okay, thank you very much. We now move to Yael vs. Gvirsman, who's an attorney and academic specializing in international criminal law. You can read more in the bio that's in the chat. She has provided advice to Amnesty Israel on the question of whether there is apartheid within Israel's borders. The floor is yours.
Thank you, Natalie. Good afternoon, everyone. Good afternoon to the speakers as well. I welcome the discussion today. I would like first to thank the organizers of this panel at the Law Faculty of Tel Aviv University, Professors Natalie Davidson, Eliav, Lieblich, and Aeyal for this really important discussion. I'd also like to thank you, Natalie, for the very important introduction, because actually it saves me time on my 10 minutes. I join Michael in saying this is one of the most challenging assignments that I've had. My contribution will focus on the Amnesty International's report named Israel's Apartheid Against Palestinians. And as you've said, I have provided a legal opinion to Amnesty International Israel on whether or not Israel is practicing apartheid within Israel borders. So let's say the green line, the 1949 armistice line. But of course, my views here are mine alone. They do not represent anyone but myself. Let's see, 10 minutes. So first, I think at the outskirts, it's very important to note that Amnesty International's report goes beyond the discourse that was dealt with until now to include all of Israel, as you've said, between the Jordan and the sea, in a somewhat something that I see as a paternalistic view, perhaps, of the only possibility for this land and for the peoples here, somehow forgetting about the possibility of a two-state, resolution of the conflict and so forth. But that's only perhaps on the political end and less on the legal end. I'll start by saying that Amnesty International's report openly triggered a great dispute also within Amnesty International's organization, We could see this in public statements that I will not have time to name all of them, but I will just quote Amnesty Israel chairperson Ms. Molly Malkar in the exclusive interview that she gave on 20th February 2022, stating that the apartheid statement was like a punch in the stomach. And later on in the interview, she states, it colored Israel in one color, opaque. I think that really resonates on my views on this, on Amnesty's report. Now, it's, you know, the great distinction, again, between Amnesty and previous reports, and I'll say also that Amnesty has a very good report, for example, on Myanmar and apartheid. It takes just comparing between the two reports to see how well-based, you know, claiming that Myanmar, the regime is an institutionalized regime of oppression and of racial dominance, to conclude that the report on Israel is, I would actually say, beyond reasonable, you know, argument or disagreement between reasonable minds. I think it is a reasonable, or it is arguable, to have the discussion on whether Israel is practicing apartheid in the occupied territories. But within Israel, it is actually, it taints the whole report with unreasonableness. And I'll try to explain why, and again, within the extent of the time allocated. So I focus on Israel as the Israel legal regime as a whole, seeing that the crime of apartheid entails two main elements of this definition beyond the regular contextual elements of regular crimes or other crimes against humanity. It entails an institutionalized regime of systematic oppression and domination, that is one. And second, the perpetrator intended to maintain such a regime. This is why I focus on the Israel regime as a whole. To state outright my view is that Israel is a democratic regime, a regime of rule of law, but with its checks and balances, its essential watchdogs and judicial remedy, and not without abuses and violations. So it's not a perfect situation, but it's far, far from being an apartheid. So after examining the question of whether or not the state of Israel is practicing apartheid as defined under international law, I reached the conclusion that the legal and material situation of Palestinian Arab citizens of Israel does not amount to apartheid under international law. In sum, this is due to the fact that Palestinian Arab Israeli citizens are equally entitled to their civil and political rights, as well as to economic, social, and cultural rights. Palestinian Arab Israeli citizens participate freely in elections. They enjoy freedom of expression, freedom of movement, freedom of association, and other civil and political rights. They can be representatives in local and national elections. They can vote same as any other citizen of Israel, and voting rates are actually relatively high, and maybe in some elections more than less. We've seen too many elections in the past 4 years. They also enjoy access to public health care, education, water, and electricity. A Palestinian citizen of Israel can exercise any profession freely, unlike the apartheid regime in South Africa. Arab Palestinian citizens of Israel hold prominent positions as lawyers, policemen, teachers, doctors, judges, including in the Supreme Court, even though they're far from being a majority, and politicians sitting in parliament and in government. Moreover, Palestinian Arab citizens of Israel enjoy collective rights with a special status recognized to the Arab language, the possibility to exercise religion freely, including to be wed, divorced, affiliated, and buried under Sharia law if Muslim, or under any Christian sect of choice if a Christian. The problem in Israel is when we don't want to include religion in these statuses and points of life. An education system in the Arab language is also freely available. The freedom to study and exercise Palestinian traditions, celebrate Muslim and Christian holidays at the workplace. The obligatory education law actually explicitly defines one of the main objectives of national education to promote Arab culture, language, and tradition so that they are freely exercised. Wherever the rights are limited by law, the limitation is not based in purpose or in effect on discrimination. And wherever this does happen, we have, very long case law, High Court of Justice reprimanding these laws or administrative decisions that in effect would discriminate against the Arab Palestinian population as a whole or against individuals. This was the case, just one example of a High Court of Justice decision, Adam Teva Vadin versus Paka Anana, or Municipality of Anana, where setting an entrance fee would have in effect discriminated against the Arab Palestinian visitors from neighboring cities or villages. Freedom of speech is, as in other democracies, limited, etc. So the main conclusion is that by law there is no segregation, institutionalized system, and so forth. Where there are discriminatory practices, in effect, they are sporadic and do not amount to persecution, let alone to racial segregation or apartheid. There are also inequalities that have to do with other issues and problems that Israel is dealing with that do not have anything to do with origin, but have to do with the equal disparity of resources geographically, the difference between big cities and periphery, the north and the south in opposition with the center. So social inequalities exist, but they are not limited to the Arab Israeli citizens of Israel. Furthermore, there is no indication that the state of Israel has the intention to perpetuate existing inequalities as required under the mental element of the crime of apartheid in international criminal law. Much to the contrary, the present government of Israel, which was born under great difficulty, releases national and municipal policies specifically designed to invest in repairing existing inequalities, and these inequalities exist. Namely, in the last budget, the government budget, the voting of 43 billion shekels in state budget allocated in view specifically promoting the Arab sectors of Israel's society.
Sorry, Yael, you have to start wrapping up.
Okay. I would like to address, after reading the 280 long page report, one cannot but get the impression that the drafters of the report are uncomfortable with the state of Israel, either as a Jewish and democratic state, because they say that since its inception in 1948, this was the situation. I would like to stress that since it was established in 1948, the state of Israel was established under the auspices of the United Nations. Therefore, it is in accordance with the UN Charter and not contrary to it. It was supported, encouraged, endorsed, and finally recognized the state of Israel as a Jewish and democratic state. I would like to perhaps end with Judge Richard Goldstone's statement in 2011 in an article in New York Times called Israel and Apartheid Slander, and where he said, in Israel, there is no apartheid. Nothing there comes close to the definition of apartheid under the 1998 Rome Statute. Inhumane acts committed in the context of an institutionalized regime of systematic oppression and so forth. In Israel, Israeli Arabs are 20% of Israel's population. They vote, they have political parties and representatives in Knesset. Arab patients lie alongside Jewish patients in Israeli hospital receiving identical treatment. My last sentence, please, Natalie.
Okay, go ahead.
The big question is whether the basic law, nation law, changed this situation, and it is enough to look at the High Court of Justice decision called 555518, where the High Court had the chance to reconfirm the principle of equality as a supra-constitutional value. Not even the Knesset can change. Thank you, and sorry for taking a bit more time.
Okay. Thank you. Our next speaker is Professor Yuval Shany, who's the Lauterbach Chair in Public International Law at Hebrew University. and served until recently as member of the UN Human Rights Committee. Thank you very much, Yuval.
Thank you, Natalie. Of course, I'm also speaking on personal behalf, and I welcome this discussion. So let me start with a personal remark. I mean, these sorts of debates always put someone like me in a bind, because on the one hand, I am a strong opponent of the occupation, of an indefinite nature of the occupation. I am in favor of a two-state solution. I think Israel violates international law in the territories, especially the settlement projects. So why am I critical of the Amnesty report? And I'm going to speak only on the Amnesty report, and that is because I think it's very important for international law to use definitions and terms in a precise way, so as to maintain some division. Of course, it's impossible to maintain a clear-cut division between law and politics. So the law is based on relatively objective and predictable categories. Politics is more subjective and objective driven. I think also accurate application of the law also comes with certain values that legitimize claims which are made on the basis of law, such as equality. We are treating similar cases alike and in dissimilar cases differently. And also we accept the fact that political processes which are legitimate generate norms that affect the calculus. So my main criticism of the Amnesty report is really about the imprecise use of the term. And if I'm right, I think this may weaken ultimately the ability of human rights groups to speak legal truth to power. Now the term, it has already been noted, the term, of course, apartheid has very particular sensitivities given its strong and offensive historical connotations. It comes with a strong stigma. It denotes extreme practices and forms of racism. And that, of course, makes this, on the political plane, that, of course, makes this label quite attractive to those who are very critical of the state of Israel. But I would argue, again, from a legal perspective, that the volatility of these charges, I mean, the nature of the charges and also their criminal context, does require as a professional measure quite a high degree of prudence in their application. Now, I do not maintain that the definition is crystal clear, and here I actually would like to differ with Agnes Kalamard, who in an interview said that the report simply states what the law is. I must say that I did follow Agnes's work as a special rapporteur, and I do admire her work as a special rapporteur. But I think on this, she's wrong. I think the law, as always is the case with the law can be interpreted in different ways. And my take is that the interpretation that has been applied by Amnesty is not persuasive. Now, on the analysis, I mean, Michael and Yael already and Solomon already discussed the definition, so I may be able to go quickly over the legal elements. I do want to underscore that this is a very the threshold, that the definition of apartheid, especially in the Rome Statute, which is the most recent and perhaps precise articulation of the norm, the threshold is exceptionally high. It is a special intent crime, dolus specialis, like the crime of genocide. And those who have followed the work of the International Criminal Courts since the beginning of the 1990s realize that it is very difficult to pursue genocide charges, because it is very difficult to actually show what individuals intended beyond reasonable doubt. And I think it is particularly difficult to do so in complex situations where there are different motives on the table, which could explain similar events. So even if in terms of the practice, and I don't actually disagree that what you see in the West Bank looks a lot like apartheid, the question of whether the motive could be actually proven is a completely different question. Secondly, there are contextual features, and the contextual features are also quite complicated, because you have to show that an institutional regime of systemic oppression and domination of one racial group over another exists. And you also have to show, like any crime against humanity, that the crime is perpetrated as a part of a widespread or systematic attack against a civilian population with the knowledge of the attack. So you have here another contextual element and another mental element. also a gravity issue, which Michael spoke about, and that is that you have to show that the inhumane acts themselves that are committed are of a gravity which would satisfy a crime against humanity. So discrimination is a violation of international law, but it is not a crime under international law, certainly not a crime against humanity. And even systemic discrimination, even systemic racial discrimination is not necessarily a crime against humanity. And if it is, it would fall under the crime of persecution, which is a more straightforward crime with a less hard to prove mental element. Now, the South African story is also, I think, important in analyzing the definition, although the Convention Against Apartheid explicitly mentions the South African story, and the Rome Statute does not. But the Rome Statute, and this is a disagreement I have often with people who take the opposite view on this, the Rome Statute doesn't replicate the definition of Sfard. Sfard actually has a broad definition of what constitutes a racial discrimination, and it's a human rights treaty that makes a lot of sense. But the Rome Statute explicitly does not mention all of these other criteria. So I think it is quite, the question of what constitutes a racial discrimination is actually a key question, because here there is a linguistic gap between Sfard and the Rome Statute. And I think, there has been a lot of literature on this. I think Carol Alingus has recently published a book, which I think is a very persuasive book on the racial, on the question of race in international criminal law. And she actually, I think she makes a strong case that racial discrimination is not only based on skin color, but for the purposes of apartheid, but it is based on racial otherness, which justifies the discriminatory treatment of the racially distinct group. And I think when you're looking at the Amnesty International report, it goes beyond this South African context in two ways, which I think are problematic. One, and that has to do with the question of Jews and Arabs within Israel, where I would agree that there is a notion of racial otherness. And I think that racial otherness does seem to have structural discriminatory features. But I think it is also, and Yael alluded to that, it coexists also with other features, all sorts of equality promotion agendas and integratory agendas, which make the situation of Jews and Arabs within Israel, although they are treated as racially other from one another in relevant part. I think it is a highly complex relationship, which doesn't have the kind of moral clarity or immoral clarity that you would find in race relations in South Africa, and it is not based on a strong, and I think it is hard to show that it is based on a strong sense of racial superiority, which the definition of apartheid seems to assume. There are other, of course, explanations for like fear of the other, like ethnic tensions, like political hostility. But in order to fall within the racial regime of domination and oppression, I think you have to really, the key element is really racial otherness, which is based on a sense of superiority and inferiority. Now, when you go to the West Bank and Gaza, here I think the situation is different, not so much in terms of the oppression and domination. And here I do not disagree much with Michael in terms of what you see on the ground. My problem is really whether we are really talking about a conflict between two races, or are we talking about a conflict between two national groups, two self-determination units, two peoples? So for instance, Gaza is probably much more akin to an interstate conflict in its features than to an apartheid, South Africa apartheid situation involving a regime, an institutionalized regime inside the state. And I do want to note that the ICJ actually, in a recent case involving Bahrain and Qatar, had great difficulties in establishing, for the purposes of Sfard, not for the crime of apartheid, the idea that nationality could constitute a basis for racial discrimination. So I have significant issues with regard to the way this is applied, and that adds on to some elements which I fear I may not have time, at least at this round, to talk about too much, and that is the loose application of motives, the discounting of other explanations for some of the policies, such as security concerns, and even expansionist. I mean, a state which tries to invade another state or take over some of its territory. This is not apartheid. This could be unsavory. It could be unlawful. It could be immoral. But it is a different kind of animal, and I think the report glosses over this, and it also deals with somewhat loosely with counterfacts, such as some of the point. I mean, the fact that Israel has an Arab party in government. I think it's an issue, and I think it's not good enough to say that this is a sort of sophisticated way to mask the apartheid regime. I think this does it a bit too easy, and there had been also a lot written in commentaries on the report about Palestinian agency and the fact that the peace process, which many of us, rallied in favor, we believed in, some of us may even still believe in, has failed due to to failures attributed to both parties, Israel and Palestine. Now, the final point which I want to make, and I realize my time is virtually ended, is I think, look, and this is really a comment about human rights group and what one would expect a mainstream organization like Amnesty to do. And I think there is something which is troubling, not so much on the analysis of the law, but on the human rights politics side, for a human rights group to tackle really the structural features that make up a state, right? So that the colonial heritage of the state, the project of the ethnic nation state, it could be economic injustice in the state. I mean, these are all legitimate agendas, but they are agendas that appeal to a very specific group constituency within the state. And that is a constituency which is open to radical political reform. When you go in that direction, you lose other constituencies. You lose moderates, you lose conservatives, and in the end, you lose the ability of human rights to talk above the political raucous to large population groups. And I think that for Amnesty, the fact that this report has not been endorsed by any government in the West and by almost any major political party in the West, and certainly only one political party in Israel, I think this is, in terms of human rights politics, I think this should be troubling. Again, for groups, for smaller groups, that's perfectly fine. I mean, it's not about popularity contest, but I think for a mainstream organization that really has, I think, a very important historical and institutional role in speaking for human rights across places and across political affiliation, I think that may be a mistake. I'll stop here, Natalie.
Thank you very much. We move on to Dr. Raef Zreik, who is the academic co-director of the Minerva Center for the Humanities at Tel Aviv University. He has written extensively on legal and political theory, citizenship and identity and legal interpretation, and more recently on the apartheid analogy in Palestine, Israel. Raef, the floor is yours.
Yeah, thank you for organizing this very important panel indeed. As a beginning, at the risk of sounding very cynical, though I'm not, I think I can agree with whatever has been said by all the participants until now. So what do we ask when we ask if Israel is committing the crime of apartheid under international law? What kind of a question is that? This is not a question how many cars are parking in the park outside, because this is not a factual question. It's a question about interpretation. Now, given the fact that we don't have any precedents, the margin of discretion is huge. It's almost endless. You read the definitions of the third of the Roma, and it's so open-ended. And the question is pretty much, it's not if Israel is committing crimes of apartheid, but we should be more clear and take more frank and political attitude. Do we want to treat Israel as if it's committing crimes of apartheid? We don't have much precedence. We are creating the precedence. And Yuval, I can make every case complicated. And you did that brilliantly. And actually, I did that in one paper on apartheid, showing how Israel can get away with it. And it can. If we want, it can. But if we want to exert political pressure on Israel, this is one way. If you don't want people to explode in Tel Aviv, this is the best way to end the occupation. This is the best way to pressure Israel. This is the best way. This is the last thing that is left to the Palestinian to struggle against Israel: occupation, oppression, disposition, 70 years of Nakba. There is a political responsibility before legal complication. We can take the legal complication wherever we want, any way we like. We know how to manipulate legal terms in every direction that we want. Now, we speak about apartheid under the shadow of South Africa. This is the paradigm. This is the metaphor. This is the analogy. Now, if we want to ask, is Israel Palestine the same as South Africa? Of course not. Of course not. I was the first to show the endless differences between Israel, Palestine, and South Africa. But this doesn't end the conversation. Here, the political responsibility starts. This is not the end. There are many differences between Israel and South Africa, but still the question persists. Now, let me be clear about one thing about the issue of crime against humanity and apartheid as a crime. I mean, I'm not a big fan of international law criminalizing all different actions. I'm not a big fan. I mean, I'm glad when Israeli sergeants and commanders are terrified when they want to fly to Europe because they get a memorandum that they might be arrested. But I don't think that this is the way to end political conflicts, really. But I'm glad that this is happening, I have to say. But I don't think that criminalization, this is the way to end political conflicts. No, no. This should be political. There should be pressure. There should be sanctions on Israel to end the occupation. Criminalization is, I'm not convinced. I'm sorry. I'm not convinced. Now, given that South Africa is the paradigm and the image, apartheid is perceived as a neat category, as beautiful category, as an aesthetic category that assume three factors: unity, geopolitical unity, separation within the unity, and subjugation. These are the three categories that occupy our mind when we think about apartheid. Within one unity, they're separated, and there's subjugation. And this is really our imaginaire when we think about Israel, Palestine. We say, no, it's not. And we heard now the example. No, Gaza is not. Gaza is just another state. The West Bank is on its way to be a state. So by this, the Palestinians are not imagined as something within the unity. They are not imagined as included at the first place and then excluded. They're not from the first place included in the political imaginaire. They're not there. And because of that, there's no apartheid. That's simply a self-determination. People in Gaza, we don't owe them any responsibility. And that's why we bombard them. We go with F-15. This didn't happen in South Africa. F-15s, people demonstrating on the border being shot like birds, 350 persons. This didn't happen under South Africa. This brutality didn't take place under South Africa. Now, in legal terms, I can show this is not apartheid because they are on their own. They're just separate. So we can say that the West Bank, because they're not included, they're not excluded. They're not thought to be included. They are simply different nationality on their way to statehood. Now, this way can last 50 years, 100 years. The mere idea of self-determination, the two-state solution, that sometime in the future they will get their independence, becomes the alibi of why this is not apartheid. So there's the ambivalence in the West Bank, and then there's the problem inside Israel. Inside Israel, there's clear unity. We are part of the system. But as Yuval and probably Yael mentioned, we're not the blacks of South Africa one-to-one. I teach at Tel Aviv. We have judges on the Supreme Court. We go to elections. We go to the same hospitals. Sometimes we go to the same restaurants as well. And this should be conceded. This shouldn't be sort of overlooked. This is an important fact. So there is total separation, but not enough unity. Within Israel, there is unity. We are part of the geopolitical unity, but there's not sort of enough discrimination. So this is one way to create an ambivalence. Now what to do actually with this ambivalence? And I want to start from inside Israel, because I think in the West Bank, it's far more worse than apartheid, and in Gaza is far worse than apartheid. Let me start by saying something about Israel and whether we want to stigmatize Israel as an apartheid state. This is a political decision that we have to decide. Now, how Israel managed to give the Palestinian basic political civil rights? By expulsion. In 48, by expulsion. Had there remained the Palestinians under the United Nations partition plan, it would be difficult for Israel to be democratic and Jewish, either democratic, either Jewish. So the Jewish democratic forced Ben-Gurion actually to expel most of the Palestinians, because had they remained, he would face either to give them right to vote, and giving them the right to vote means that it's not anymore anymore Jewish. It threatens it, or he would deny them the right to vote, like in South Africa, then it wouldn't be democratic. The infrastructure of our civil rights is the expulsion. Now, for many Palestinians who live in the refugee camps, apartheid is a demand, not a problem. They want to come back and to live under apartheid. It's the solution, not the problem for them. Now, what is missing from all this discussion, and from Amnesty probably, I read it a while ago and I don't remember every. What is probably is hidden from the conversation is that the refugees are living under the Israeli regime. Israel is imposing on them non-return. What is excluded remain included in the structure of the state. There's a difference if you drink coffee without milk or coffee without sugar. What is negated become determination of the thing that there is. Israel continue to control the life of 5 million Palestinians who want to return. This is a structural element of Israel. This should be taken into account and not to be dismissed. So the issue of the same regime. Now, I must say, my life are not equivalent to life of someone in Jenin or in Gaza. That would be completely dishonest to say that. I travel, I have a passport, I write, I teach, I go to hospitals, and I enjoy different rights that they do not have. The fact that Israel would like to see as minimum Palestinians here and in the West Bank doesn't mean that it treats us the same. It's probably have the same fantasies about our disappearance, but that doesn't make that we are all the same. But when you want to describe a regime as practicing apartheid, I don't know how many people must be the victims of the apartheid. Is it a characterization of the victimizer, or is it the, I mean, how many people must be there in order to say that a crime is being committed of apartheid? And when I say a crime, I'm not speaking in terms of the Roma Statute. I'm speaking about international public law. You know what? In political terms. I'm speaking even in political terms.
Sorry, Raef, we have to wrap up.
Yeah, 1 minute. 1 minute.
Sure.
So the issue of self-defense. Israel can portray everything it does as a self-defense. Apartheid is a system of self-defense. But I want to remind all of us, most crimes in humanity between groups were under the illusion or the fantasy that you are under self-defense. Most expansions, empires in history did that under self-defense. Racial, I mean, the distinction is not racial, but I don't know why that is, must make a difference. Ideological, probably the Zionists didn't come here with a clear racist theory against the Palestinian, but all these things develop with times. Many times praxis precedes ideology. Ideology emerged with the time in order. So I would stop here, and I want to emphasize at the end, I agree with all what have been said. There is a political question that before and after the legal debate. That's why probably I don't teach at the law school at the end.
Thank you very much, Raef. Our last but not least speaker is Dr. Halakhuri Bisharat, who is the academic director of the Law School of Ono Academic College, Haifa campus, and a lecturer here at Tel Aviv University. One of her main areas of expertise is international criminal law.
Thank you, Natalie. Thank you, Eliav and Aeyal, for inviting me, and thank you for the organizers. The apartheid debate in Amnesty's report raises many interesting legal questions. Whether there are two separate legal systems in the occupied Palestinian territories and Israel, and whether Israel is exercising an apartheid regime in Israel. I'm not going to examine those, but I want to contend that the policy and practice of Israel's officials, according to the nationality and entry into Israel law that prohibits Israeli Arab citizens that chose to marry Palestinians from the OPT and outside Israel to live with their spouses in Israel. And thus they violate their rights to family life, which may, in my opinion, amount to the crime against humanity of persecution. The Rome Statute defines the crime of humanity, crimes against humanity of persecution as the intentional and severe deprivation of fundamental rights contrary to international law by reason of the identity of the group or collectivity on political, racial, national, ethnic, cultural, religious, gender, or other grounds. They are recognized as impermissible under international law. Customary international law defines the crime of persecution as containing two basic elements. First, severe violations of basic rights that were widespread or systematic. Two, with the specific intent to discriminate. The right to family life is an integral part of the right to citizenship. There's a very strong connection between the right to family and the right to citizenship. If a citizen cannot live with his spouse and children that he loves in his own country, then he or she would have to leave their homeland country and give up their de facto their citizenship. Family life is the essence of citizenship. My legal claim is based on Hassan Jabarin's article, How the Law of Returns Creates One Legal Order in Palestine. The article presents a case law study regarding the family life between spouses and their children in Palestine and Israel since 1948. This is the first legal article that demonstrates that in the case of family life, there is one legal system in the OPT and Israel, the same rule of law. The case law could substantiate elements of the crime of persecution. Israel's policy in family unification cases pertaining to Israeli Arabs and their Palestinian spouses substantiate a hierarchy in citizenship and a flagrant violation of the right of Israeli Palestinians to family life. The Israeli Arab citizenship is out of the defense of the law. They became foreigners, we became foreigners in our own homeland. There is no other country in the world which prevents its citizens from family unification on the basis of their national belonging. Israel claims that the law of return, maintaining a Jewish demographic majority in Israel, do not lead to discrimination against Palestinian individual citizens, the insiders. There are only matters of group rights for the Jewish as a majority. As noted in Qa'dan case, the law of return only concerns the right to enter the gate of the home, but once inside the home, every citizen is equal before the law. This assertion is an illusion. The case law shows that Palestinian family life is treated as a humanitarian issue and knows no legality in Israel and Palestine, regardless of geography. But by contrast, Israeli Jewish family life enjoys the applicability of the Israeli rule based on law of return, regardless of geography. All the justices who dealt with hundreds of Palestinians' family cases since 1955 have shared in the suspension of legality. The case law shows us that court decisions create racial domination. The citizenship rights of the Palestinian citizens of Israel are neither a constitutional right, not even a legal right. The main principle of the Constitution is domination, where race is its basic unit. Domination appears when the court negates the equality before the law, the national law, as required by international human rights law. Palestinian family unifications cases before the Supreme Court, which challenges the foreigners, is met by domination and exclusion by the court. The values of hegemonic ethnicity, Jewish and democratic state, are the sword of domination, fragmentation, and separation of Palestinian families. A serious deprivation of fundamental rights could amount to the crime of persecution, according to the case law of the International Criminal Tribunal for the former Yugoslavia. In the Tadic and the Koprich's cases, the trial chamber stated that it is the violation of the right to equality in some serious fashion that infringes on the enjoyment of basic or fundamental right that constitutes persecution. Persecution as the gross or blatant denial on discriminatory grounds of a fundamental right laid down in international, customary, or treaty law. Now, with regard to the crime of persecution, a particular intent is required, a discriminatory intent. The basic law, Israel, the nation state of the Jewish people, I claim it demonstrates the intent of the Israeli regime to constitutionally anchor the Jewish dominance, and therefore the basic law also, Israel, the nation state of the Jewish people, reveals constitutional identity which is based on we the people, we the Jewish people. It is a leading legal principle as regards citizenship. Its leading legal principle regarding citizenship is separate and unequal. The basic law, this basic law demonstrates the intent of the Israeli regime to constitutionally anchor the Jewish dominance, while simultaneously anchoring discrimination against Arab citizens and legitimizing exclusion, racism, and systematic inequality. Thank you. Thank you, Natalie.
Thank you very much. Thank you very much. You even had 30 seconds left. So great. So we're now going to take questions. If you want to ask a question or make a comment, please raise your hand electronically. I will take these in groups of 3. Okay, we'll start with Aeyal Gross, Sandy Kedar, and Yasser Abu Arisha. So Aeyal first. Aeyal,
Hey.
you're on mute.
Okay, can you hear me now?
Yes.
Okay, so can you unmute the other user, sorry, from a computer, because I'm not a host there and I prefer better speak from the phone, sorry.
Yes.
Okay, because I had the user from the iPad, I'm turning it off. So you can hear me now, yeah?
Yes.
Can you hear me now?
Yes.
Can you hear me now?
Yes.
Sorry.
Yeah, we can hear you.
Oh,
Okay, Aeyal, maybe we'll move on to Sandy while you fix the technical issues, and we'll be right back to you, okay? So, Sandy. Sandy Kedar, oh, sorry. Sorry, 1 second, Sandy.
Okay. So there is some echo. I don't know.
No, you're fine.
I'm fine. Okay. So thank you very much for organizing this important debate. I want to make several short remarks. The first one is that I'm ever amazed by the formalism of some of the speakers. Yuval, you talk as if there is no, and also Yael, you talk as if there is no legal realism. There is law in the books, and there is no law in action. I mean, I'm just amazed by this. Yael talking about equality, talk about Umm el-Khiran in Israel proper, about the fact that Bedouins are ousted in order to build a Jewish settlement. I mean, in Israel proper. I mean, and it's all done under the permissions of the Israeli Supreme Court. Talk about committees after Qadan, acceptance committees to Jewish that are practically closed, almost practically closed to Arabs, citizens of Israel. And of course, if we move about this unexisting green line that is only exists in order to legitimize to the good leftists that are remaining to legitimize Israel democracy within the green line, because the green line does not exist anywhere. Elections are voted, and the people that decide the votes are Israeli electors from the occupied territories. These otherwise, if everybody was voting, we'll have here, I don't know, a joint Shas-Hamas government and Aguda, and if only Jews within, only Israeli citizens within Israel would have voted, probably there will be different results. So I think that this use of categories, including the spatial category and the historical category, as Raef has so well demonstrated, that if we started the zero period at 1948 and forgetting what's happening, and then we create an artificial border that does not exist. If you hear the government speaking about why Israel is not at apartheid at one side, and speaking about the fact that all of Israel is part of a territories, and whoever is talking about Aeyal is committing, cannot receive Israel prize, and all. So now 2-1 it was decided. So that's one
Sandy,
thing.
we have a long list of people who want to,
okay, the second thing is to it's also to Michael this distinction between the green line and what's going on. And finally, to Solomon Sacco, I think that your analysis of the situation in Israel is taking too far. I mean, if what you define about Israel proper is apartheid, I think as itself, many other countries fit into the definition of apartheid. However, I think that as well as you could talk about United States as a slave state, even though only the South was a state yet, the federal state was a slave state. And there is one regime in Israel. And therefore, Israel is an apartheid state, not because there is apartheid within the Green Line, but because it's a one regime that practices apartheid on the other side of the Green Line.
Exactly.
Thank you.
Okay, thank you, Sandy. Aeyal, your turn.
So I have to say I very much agree with Raef that we can make legal arguments on both sides, and it's really a question about the symbolism and the political choice. And based on that, I want to make two short comments and questions, especially to Yuval. I have to remember when we talk about South Africa and make the comparison, even if it's not necessarily has to be like South Africa, we talk about different benches, different restaurants, but that's what was called small apartheid. And we have to remember grand apartheid. And this goes, Yuval, also to your point about Gaza is maybe and West Bank, maybe about self-determination struggle. But to a large extent, we have to remember the South African argument was separate development. And it was a Bantustan. They are now their own state, which will exercise their own self-determination. And they are not anymore South African citizens. So I think that, if we want to make those comparisons, we also have to look at those elements. And we have to remember that also there was a difference between, let's say, apartheid for South African Black in Soweto and one in the Bantustan. So there are also differences in practices and contexts there. So this brings me to the question, and I want Yuval to ask you the question in a way to return the question you ask Amnesty. And I want to ask, what is our position as human rights lawyers, as Israeli human rights lawyers? Do we have to take the most narrow definitions, the most narrow only criminal context, that we have to always think what are the alternative explanations? So I think when I hear this kind of discourse, I wonder, what is stake? You ask what is stake for Amnesty to make this choice, and I want to know what is stake for us to make this choice. And is it something that really scares us? We can say the occupation is illegal, maybe settlements are illegal, but what is stake for us that so much scares us from this world that we want to take the most narrow, only criminal definition, etc. Thank you.
Okay, thank you. Yasser.
Yes, good evening, everybody. Natalie, I feel so privileged to be within the first group to give the question because you were my teacher. And
Okay.
thank you, and thanks to Aeyal and to Eliav for arranging this. I want to make a small remark for what Raef said from before about mass killing for civilians. In South Africa, it actually happened 62 years ago in the township of Sharpeville. The police of apartheid South Africa shot dead about 250 people who demonstrated against the pass laws. So it happened, it was violent. But I agree with you to agree with everybody, Raef, but I will give you the question at the last, because I have two questions actually. The first is to Michael. If it's that easy to prove that apartheid exists in Israel, why is nobody is like very interested in this? It feels like it's boring people, and Israel continues to make allies around the area and around the world, like peace agreements with Arab states. Everything is okay. What apartheid are you talking about? And for me, like as a Palestinian, I don't agree to describe Israel as an apartheid state for many reasons. Also because of the reason that we don't need to use the legal activism to make a future arrangement between the people who live in Israel. And second is apartheid is the name that the regime of apartheid called themselves. Nobody called them this way. They called themselves this way. It's apartheid. It's like making people, making the people thrive and make a good life in separate ways. So this is the question for Michael. And secondly, it's also
so you have to be very brief.
Yeah, it's very short. It's for Amnesty and for Raef. I don't understand why people and organizations really very insisting to use the case of apartheid. Apartheid, nobody was convicted for anything. De Klerk lived his life very well until the end of his days. Nothing happened when he was convicted. Why to use this and for what? This is one thing. And the other thing, I think that all these organizations forget to talk about one very important place before the apartheid. It was the colonial Algeria. The practices of France in Algeria are way more similar to what's happening in Palestine and in Israel, more than the apartheid South Africa, and nobody is talking about this. And this is a point that I think that all the organizations and all the scholars should rethink about their ways in this thing. I will be glad to hear about what you say.
Thank you very much. So we have questions for Michael, Solomon, Raef, and Yuval. I'm going to ask each of you to go ahead. Maybe Raef, you can begin. You don't have to address all the points that were addressed to you. If you just want to pick one issue each to respond to one or two issues.
Oh, actually, there was one question addressed to me.
Okay. I thought I heard your name mentioned more, but yes, sure.
Yeah, but as a question, it was
Yasser's
why to use apartheid? We hope it helps. We hope someone would feel that it's embarrassing that his country is called apartheid, and that probably foreign countries would start to put pressure on Israel. If this helps, that's fine. That's all. Anybody who wants to end occupation, equality, that's fine. Apartheid, occupation, I mean, not insisting on one thing. Anything that can embarrass Israel in this regard, That's fine. That's good reason.
Okay, thank you. Solomon, do you want to respond to any of the questions and comments?
Well, first of all, thanks, yes. We say apartheid because it is apartheid, and it's our job as human rights activists to document human rights violations and to advocate for their end. And it is it is apartheid in all areas under Israeli control. That's clear from the report. It's clear from a number of reports. Amnesty, B'Tselem have said throughout the area. Human Rights Watch has said clearly apartheid in the occupied territories, persecution with the intention to dominate inside Israel. One of the speakers referenced Goldstone. We could reference so many people. We could reference Tutu, but that's not the point. The point is Amnesty International looked at the facts, analyzed this, and meeting the test under international law. And there is a system of oppression and domination by one state over one people for the benefit of another people. Yes, it is experienced differently in different parts of that territory, and our report is clear on that. But the discrimination that is suffered inside the Green Line has to be understood against the background of the Nakba and the ethnic cleansing and the expulsion. It has to be understood against the background of demographic considerations. And it has to be understood against the background of resource theft. It has to be understood against the background of the forced displacement of the Bedouin communities as we speak, forcibly moved out of their houses so that Jewish Israeli communities can move in. So we say apartheid because that's what it is. And we say apartheid so that Israel dismantles the system. And that is our intention, is to push for equality between Palestinians and Jewish Israelis and Palestinian citizens of Israel. And that's the fight that we've taken on here.
Okay, thank you. Yuval, any responses?
Yeah, I mean, I think I can be, do you hear me, Natalie?
Yes,
because I
yes.
see myself on the screen. So yeah, I mean, I can be rather brief. So Sandy is concerned about formalism. I think you have to be careful not to engage in excessive formalism, but I think that when you apply legal categories, and you have different legal categories that are relevant, and we heard about persecution, we heard about self-determination, we heard about systemic discrimination, and I think actually invoking plausible categories does have some importance. So I don't actually disagree with the factual analysis that Sandy offered, or the Aeyal offered, to a large extent. I'm just, my concern is about overclaiming. This also goes to Eyal's point. I mean, what should human rights lawyers do? I'm not talking about activists. I'm talking about lawyers. I think lawyers should play their hand in a responsible way, which means that you make claims which are well established, which could be well substantiated. I think by overclaiming, in a way, you may harm your cause, because a lot of the discussion would not be now on settlements, or would not be on deprivation of the right to self-determination, and the status quo, and the fact that there is no political process, and what's happening in Gaza. And I agree that the Bantustan analogy is relevant in terms of there are many factual similarities. But we are now spending a lot of time on arguing on something which I think is very hard to show, that every one of these oppressive measures is really, or originates from a certain idea of racial superiority, and not from others. So we are in a way spending a lot of time and a lot of energy on a trajectory which I think is not helpful, and I also think is legally very, very problematic. And just a final sentence. I mean, if you look at the Amnesty report, what is the final recommendation? It is that and we just heard Solomon talking about the Nakba and basically the right of return. So this is also, I think, a question that human rights lawyers, but also activists should confront, and that is how there to promote interpretations of the law that, and I fully agree with what Raef just said. Are we promoting interpretations that eventually make the lives of people better and help solve the underlying problems? Or are we climbing very high trees in terms of the legal statements that we made and the legal remedies that we prescribed in ways which would make it more difficult to address injustices than actually to fix them? Thank you.
Thank you. Michael, do you want to add anything?
Two short telegraphic almost points. As I said before, the question of the crime of apartheid, as opposed to different uses of the term under different disciplines, political science and otherwise, crime happens at a certain place at a certain time. And I agree with Sandy's framework that the crime of apartheid is being committed in the occupied Palestinian territories. It doesn't matter if we analyze the question with a wide geographic scope as one system between the Jordan River and the sea, or whether we focus on the military regime, for example, in the West Bank. In all analysis, eventually, all the components of the crime only materialize in the OPT. And while I am very much concerned about the question of fragmentation, and this is the one thing that I was obsessive about because I do not want to contribute to the Israeli policy of fragmenting Palestinian people, one has to recognize that the distinction between Israel and the OPT is not an artificial one like the Bantustans, which was created in order to create an alibi. This is, if it was up to Israel, there was complete annexation already. So it's not artificial. There are still some differences in the institutions, in the normative framework. And the last word, I have to say, Yuval, I strongly oppose your theory of interpretation. You cannot interpret a central key component of international law, one that is the result of hundreds, maybe thousands of years of human experience in order to define what is prohibited, like you interpret insurance policies or contracts. When we look at the definition of the apartheid crime, what does it protect? It protects the value of our common humanity. And so when you look at the question of what is racial group, you cannot look at it as something so narrow. Any type of classification that is the basis for exclusion, for subjugation, for discrimination, etc., is to be seen as a racial classification, and that is what the third convention agrees with, and that is what human experience wants us to eradicate.
Okay, thank you. So we're going to take as many questions and comments as we can from the audience.
Excuse me, Natalie, if I may, I think Sandy's remark also accused me of...
Okay, sorry. Yes, sorry. Go ahead.
Briefly. Just to say, Sandy, that when addressing the report, I also don't share the taste for over-formalism and to see the human being at the center of all the causes that we deal with. However, my concern with the report is drastically overlooking what exists, what the Israel regime is, what the legal regime is. And I think any sound criticism in order to have power has to say what it is. And therefore, this was my point. On the gentleman that Yasser Abu Arisha, who spoke and said about he's completely correct about the Shortville killings, 250 people. The difference within Israel was the Or Commission and facing the 13 deaths of youth in the October 2000 demonstrations and reparations that followed. That's it. Thank you.
Reparation
you
that
very much.
followed? What reparation? Can you tell us about reparation?
Natalie, if you may, I'll answer.
Yes.
So the Orr Commission, composed of Judge Theodore Orr and another district judge of Nazareth and a professor from Tel Aviv University, reached certain conclusions. There were no criminal filings, but the families filed lawsuits, and based on the recommendation, the State of Israel paid reparations to the families, to the plaintiffs in the lawsuits, to settle it out, as was accepted by the court. I brought students to The Hague to meet Professor John Dugard, and one of his claims was one of the first features of apartheid is the lack of reparations. So this is, the State of Israel paying the victims. I'm not saying that it's enough in any case like this, but reparations do exist.
Okay, so we'll take a few questions, as many questions as we can, and that all depends on the brevity of the people asking. We'll start with Smadar Ben Natan. Sorry, Smadar, I have to unmute you.
Okay, thank you so much for having this discussion. I should say I'm in the United States, and apparently it's easier to have this discussion in Israel and not outside Israel, and specifically in the US. I think a lot of the question of how we judge or how we assess apartheid is what is the perspective that we're taking. And are we looking at the experiences and the de facto regime over the oppressed, or are we looking into the justifications of the oppressors? And I think part of what Yuval and Yael were doing in interrogating intent is looking into the justifications and not into what is actually happening on the ground. No regime today would openly claim that it is practicing apartheid or a racial separation, as South Africa was openly practicing racial segregation. We're not there anymore. So questions of nationality and ethnicity are replacing race. And the question is, what is happening to people on the ground? And it's many people from within Israel have a hard time accepting the framework of apartheid because they do not experience it. They look only at themselves and at their neighbors, and looking at Israel separately from the occupied territories, and then it doesn't feel like apartheid. And I want to tell you that just a week ago, I entered where I shouldn't enter as an Israeli citizen, Israeli Jewish citizen, the 8 territories, and I went back. And in the checkpoint, the soldier that was checking my ID asked, Smadar, are you Jewish? He did not ask, she did not ask if I was an Israeli citizen. And my car was searched, and I was searched because I was Jewish and I was not supposed to be there. The soldier that came to me and told me that I broke the military command told me Jews are not supposed to come here. They did not say Israeli citizens. So there is, like Sandy said, the law in the books, and there is the law in action. And what happens on the ground is a fragmentation and separation on the basis of, are you Jewish or are you not Jewish? These are the commands that the soldiers get. And this is the experience of the oppressed, that if you look only at the law, you don't get it.
Thank you. So that I want to move on. We only have 10 minutes officially. So thank you very much. Dejen.
Sure.
Dejen.
Hello.
Yes, go ahead. We can hear you.
Okay, thank you for the awesome presentation. So my question is a bit of a general question. So ever since the establishment of the State of Israel, we know that there have been a number of resolutions to the Palestinian question. So now there seems a belief that international law can respond to the problems of the Palestinian questions. So, but my question is, would the future hold this water or a promise for Palestinians for them to have a solution on the basis of international law? Wouldn't speaking the language of international law be something that can't bring a real solution for the Palestinians. So that, for instance, we have been talking about the law of occupation. Now there is a language of apartheid. Would that be the case, because that international law seems to have been failed to bring realistic solution to the Palestinian question? Thank you.
Thank you. Rezek.
Hi, hello. So thank you for everyone. I have two short questions, one for Mr. Michael and one for Mr. Solomon. Mr. Michael, you talked about how it's still possible to separate between the apartheid question in the occupied West Bank and Gaza and between the same question in 1948 borders. So I'm sitting here in my village that is being suffocated by Ma'aleh this and Ma'aleh that, and I don't feel that this separation can do anything but to normalize the apartheid inside the 48 borders. So don't you think that this separation can really hurt Palestinian citizens of Israel and deny them from the right to raise this question if it's being raised by Gaza and the West Bank in the first place? So Mr. Solomon, I wanted to ask you, do you think that it's enough to say there's apartheid without trying to address the roots of it? Can we say that every application, that there is any application of Zionism that won't lead to apartheid in the end? And if we discuss the situation without addressing the roots, can we really reach a solution or reach something that we can talk about how to end this situation? Thank you.
Thank you very much. Charles Shamas.
First of all, I was intrigued by the pragmatist discussion, which was a question of, is this effective? Is this an effective way to invoke law with a view to activating process of remediation or restorative justice? And I think this is a very valid set of issues to raise, because lawyers choose their law also because of the effectiveness in realizing the just cause they seek to represent. But I couldn't stop but thinking of the fact that South African apartheid emerged from basically the possession goals of the colonists. There was a colonizing process, and the thing matured and developed into a system of apartheid because acquisitive goals, possession goals, needed to be satisfied, and they were over land and perhaps also over people, use of people, but certainly over land and natural resources. And I look at a lot of the Zionist literature and Zionist political expression, and I look back and say, well, this was a movement of attachment, possession goals to the land of Palestine. And they encountered, Palestinian, indigenous, Arab inhabitants. And the story unfolded, in my view, from there. So whether you call it apartheid or not, there is a question of dominance, domination, appropriation, taking possession and control, transferring away possession and control from others, causing them to flee, weakening them, intimidating them, subjugating them. All of these take a variety of forms and are regionalized in the current system. But it all goes back, in my view, to this administrative ordinance, I think number 29, from 1948, which defined as one of the basic administrative acts or legislation, the special relationship, unique relationship of the State of Israel to the entire territory of mandatory Palestine.
I'm sorry, Charles, I have to cut you off to
That's
get
it.
to the
Thank
last
you.
three. Thank you very much. So we're going to give each of the last three participants who have their hands up 1 minute to express themselves, and then we'll, if the speakers agree, we'll take another 5 to 10 minutes to see if anybody wants to comment or respond. So Oren Yiftachel.
Thank you very much. I have to go at a record neck-breaking pace. The debate is important, yeah. Like Sandy Kedar before me, I'm amazed at the lack of willingness to look at the overall picture. Now, when we identify a regime in the social science and also in law, we have to identify the entire system. We cannot just go to a house and say we just choose one room and we don't look at the other. We have to look at the entire house and try to characterize it, what's happening. And of course, this house has been colonized over the last 100 years, has been colonized. So it's not just de facto, it's also de jure, but the de jure is not always the law exactly. That de jure would be regulations, would be plans, would be orders. All this is a legal regime, which all the bases are, of course, moving in one direction. The basis of the regime, demography, immigration is one direction, security is one direction, settlement. We have 1,176 settlements, and we haven't had one Palestinian settlement where there was except concentration of the Bedouins in about 30 of them. Allocation of land, allocation of resources. So Yuval and Yael, you cannot just ignore it, say we only look at one room or two rooms, we don't look at the rest, and we don't look at the process. Now I want to suggest to you an analysis that I came to the conclusion how to resolve the conundrum, because you are also right that the Palestinians in Israel, the Arabs in Israel, have greater rights than the Arabs in the occupied territory. But if you look at the entire territory, and I want to ask you, Shany and Yael, can you ignore that Israel is controlling the entire territory? And for good, you saw the peace plan by Trump, etc., Israel for good. We then have three basic types of citizenship: white, colored, and black, if we refer as an analogy to South Africa. And we have different packages of rights and possibilities and capabilities. And this is apartheid. We have de jure, different types of citizenship under a regime in a territory that for the foreseeable future, maybe not 100 years, but definitely for the future generations, will be under Israeli Jewish regime. So please answer to that kind of analysis.
Thank you. Jed.
Thank you. I have a question for Solomon. I find the Amnesty report very vulnerable on its facts and analysis. And I think the tone of Amnesty is very kind of arrogant. And I actually think it's a big problem for Amnesty because it's shooting itself in the foot. For example, and this is a question, in the report, it says that the Gaza blockade is illegal and a crime. But the UN report in 2011 said it was legal and appropriate. Amnesty didn't mention that. I don't understand why Amnesty didn't mention that in the report, at least as a counterpoint. That's very unprofessional, especially if you're accusing somebody of a crime. That's just one quick example, but it's a really serious one, not to mention a UN report saying that it is legal. Also, Amnesty doesn't talk about, so that's a question, why didn't it mention that? It doesn't talk about Resolution 181 and it being a Jewish state. The whole core of the matter is the international law says that there should be a Jewish state and an Arab state or Palestinian state. The report totally ignores Resolution 181. It's a massive flaw. It doesn't get up and celebrate it. You're supposed to be supporting the law. The law says Jewish state, and you have to come full throttle at what the law is. And you're also meeting with people constantly that don't believe in that. So by association, and nobody's jumping clear on it, why don't you go and say, we support Jewish State 181 right in the front cover of the report? And also, if Omar was the prime minister and had the intent to give away 95% of the West Bank or whatever now, and he had a majority in the Knesset, does that mean it's not changed the total analysis? Because
thank you, Judge. I have to cut you off. Sorry. Thank you, Ruth.
Thank you very much. I'm a member of the public who received an email and was interested. I've thought a lot about these things, and I think what everyone's been talking about in a way is about framing of the issues. And the frame is of law, specifically international law, and it's also the frame of comparing to apartheid South Africa. And I see that this kind of framing has not got us anywhere in terms of achieving justice or safety for either people. Obviously, some have suffered worse than others. Ever since the Israel is an apartheid regime frame was introduced, I believe in 2001 at the Durban conference, it's the main thing we've seen is a rise in anti-Semitism in Europe and on university campuses in the United States. I feel it's not a useful frame, and it leaves out a lot of things. Outside the frame is the entire history of the Jews in the Middle East and North Africa. Outside the frame is so much that I'm not going to say it.
Okay, so Ruth, I'm sorry, I'll cut you off because we're already over time.
I want to ask the roundtable, what different frame would you choose that you think would be more productive? Would you choose maybe Liberia, where the former slaves returned to Africa, but there were people living there? Would you choose Czechoslovakia, where two peoples decided to split the country? Maybe Estonia, where the Estonians had been so decimated that they were concerned that the Russians living in Estonia, now it was independent, might nonetheless overwhelm them. Please choose your frame.
Okay, thank you very much. We're over time, and we're going to take another 10 minutes to be over time if no one has to rush away. Hala had to go, unfortunately, she's teaching. So speakers, each in turn, if you want to make any final comments. Yael, we'll start with you. If you want to.
Yes, you took me off guard for a second. Yes, thank you, Natalie, and thank you for the questions. I'm not sure what was directly addressed to me.
No, just final comments if you have any. If you don't, that's fine.
Final comments, perhaps piggybacking on the final previous comment, is that I am persuaded that we have one land and that we are destined to live together no matter what. I am also convinced that we need justice for both peoples and all individuals, which is sometimes two conflicting matters. And I wish that wherever there is criticism, it is a credible criticism that we can actually deal with and that will be constructive. Thank you.
Thank you, Yuval.
Right, a lot. I don't know how much I can cover in I don't know, seconds that I have. Maybe I'll react to Smadar and also indirectly to Oren. Yes, I mean, it is frustrating. I mean, lawyers are frustrating, professionals in that they sometimes insist on basically following ideology that leads them to a place which is in dissonance with the living experience of people. That's the weakness of the discipline. It also has, as I said before, advantages. With regard to Smadar, you're perfectly right. It is a special intent crime. Since we're talking about a special intent crime, the focus is on the intent. It's not on the living experience of the victims of the crime. It's on the intent of the perpetrators. And here, I think it is difficult indeed because both say it actually proclaims that it pursues apartheid. And I think apartheid was particularly odious because it was an official state policy. And I think when you move farther from proclaimed apartheid, it's more difficult. And heard there are other options in terms of other crimes which may be more suitable for this. Maybe I'll say two very quick things in that regard. One is that the issue of living experience, of course, cuts both ways. I mean, we heard a lot about the Palestinian living experience, which I know, I don't doubt it's, the tragedy of the Palestinian living experience. But if you're talking about living experience, there is also living experience of Israelis, for instance, around Gaza, who are terrified about the situation in Gaza. And I think that also affects the analysis of intents. So living experience would cut both ways. And with regard to Oren, does Israel control everything? To some extent, yes. Does it wish to control everything? Do all governments from 48 onwards wished always to control the Palestinians and never actually find some accommodation? I think that's a bit of an essentialist analysis of the Israeli story, and I would have some reservations about it. Thank you.
Thank you very much, Solomon.
Thanks. Yes, very, very quickly. Firstly, special intent can be inferred from the actions of the oppressor, and I think it's relatively easy to do that. So obviously, we're not going to get into that here, but I think it's important to recognize and accept that you can infer intent from the actual situation on the ground. Another question that was whether apartheid is a sufficient tool of analysis, and a number of Palestinian activists make arguments around colonialism. There was argument here about acquisition being the intent, and I think all of those are relevant and important frames of reference. But those are not the legal ones that Amnesty had at its reach to analyze the situation, and we used the legal analysis that we had. On the technical questions around the flaws in the report, no report is perfect, but the examples given, I would happily discuss at length about different UN reports on the legality of the Gaza blockade, and just to reference the ICRC, which very strongly refutes the legality of that. I'm happy to have that conversation, perhaps in a more professional environment and less in a talk show.
Okay, thank you, Michael.
The Israeli society is suffering from a very serious disease. And in order to cure it, we need to identify correctly the illness. And we have for many years thought the occupation describes the illness. And it was not only an occupation, and it was not only what we saw, what international humanitarian law suggested, and we didn't manage to dismantle it because there was much more than that. And as someone that is for the last 25 years is making much of his time is in the corridors of the Israeli regime in these areas, I am drowning in molecules of intent. I see them everywhere. I see them every day. I see them in every policy and in every practice. I have absolutely no problem proving the intent to dominate forever the Palestinian people and the Palestinian lands. And if we will not acknowledge that this is what we're facing, we will not be able to end it. South Africa self-proclaimed apartheid before it was declared an international crime. And even then it took 20 years to end the South African apartheid. I hope it will not take 20 years here, but even if it will, we will dismantle it.
Thank you, Raef.
Yeah, I'll say a few words. One about the increasing necessity of apartheid is because the category of occupation is running out. It's beyond expiring date. It cannot conceptualize the fact that it's permanent and that it's not ideological and that the settlements are there to stay. So we need new tools to analyze the reality beyond the temporality. The temporality, the idea of occupation as temporal situation works as a disguise of the need to conceptualize things as permanent. And I want to finish with something not related to the apartheid, but something more general about this idea of intentionality. I mean, I did my dissertation on Kant, and we stuck with Kant and with the idea with the goodwill. The goodwill is problem. When we speak about politics, we should probably put the idea of goodwill and intentions. Probably Israel didn't intend at 1948 to expel Palestinians. It expelled them. Probably they didn't intend to prevent them from coming back. It did. Probably no one intended to have a military rule inside Israel for 20 years. It did. In 1967, probably Israel didn't plan to occupy the rest of Palestine. It did. When they bomb Gaza, probably they don't intend to kill civilians. It's just a side effect. It's a double effect, but it does. The rhetoric of intention works to distance us from the results, material results of our action. Please, please try to get over the idea of clean hand theory and start to see the result of the action, not only the intention of the actor himself. I think that's a good beginning for reconciliation.
Thank you very much. And if we thank you, Raef. And if we accept that position, then we have serious questions about the appropriateness of the criminal law frame. Even if we accept we can take a legal and international legal approach, but that poses questions about the framework of criminal law, which has become dominant. Thank you very, very much to everyone, to the speakers who took time out of their busy schedule for a very important discussion. Thank you very much to the participants, and we hope to continue this conversation. It's only the beginning of this discussion.
Thank you all.
Thanks, everybody.
Thank you very much.
Thank you.
Thanks, everyone, also from me, the debate.
Thank you. Bye-bye. We are done.
Bye. And again, thank you, Yuli.